Welcome to Credit Training Program.
Unit 1. The borrower's business. Type of business and product or service. What does the business do? It is important to understand the types of products or service the business delivers. What is the product or service? What is the demand for this product? Does the company manufacture a product that is sold to a very small number of specialized customers, or it is a retailer that sells products made by others based on its convenient location? We should define whether the company is manufacturer, distributor, or investment in fixed asset, or is it more labor-intensive business. These distinctions are very important because they offer clues about the cash cycles, the likely borrowing causes, what the financial statements may look like, and the opportunities for financial services. Legal structure and ownership. What is the legal structure and ownership? You need to be aware of the differences among the different business structures, especially regarding cost and ease of establishment, liability of the owners, continuity of the business, management control, ease of raising capital, and tax implications. These are 5 basic types of business organization. 1. Sole proprietorships. 2. Partnership. 3. Corporation. 4. Limited liability company, LLC. 5. Business trust. Sole proprietorships. Sole proprietorship or individual ownership is the simplest and least expensive form of business organization to establish. Only one person can own it. Cost and ease of establishment. An individual creates a proprietorship simply by starting a business and declaring it a sole proprietorship. Liability of owners. In a sole proprietorship, the individual owner is personally liable for all debts of the business and therefore has unlimited liabilities. No distinction is made between the owner's personal assets and the business's assets. There is no legal provision for continuity of sole proprietorship. This type of organization is the individual who owns it. If the owner were to die, the business would terminate. Management control. In a sole proprietorship, the owner has all the control and authority to make all management decisions. There are both advantages and disadvantages in this centralized decision-making process. One advantage is that sole proprietors can make decisions quickly. A disadvantage is that sole proprietor can divert capital for any purpose. Ease of raising capital. Many sole proprietorships find it difficult to raise capital. Tax implications. A proprietorship does not pay taxes on income. The owner then pays taxes at the individual rate on all the net income that he or she accrues from the business. Partnerships. Partnership is a business enterprise in which 2 or more entities combine their money, property, skill, and labor, or any combination of these items, to form a business as co-owners. Partnerships may be made up of individuals, other partnerships, corporations, or combinations of those. A partnership can be organized as a general partnership or as a limited partnership. General partnership are often operating business partnerships, in which partners share in the management responsibilities and the business liabilities, as well as in the profits of the business. The limited partnership structure, on the other hand, is frequently used for investment partnerships. This structure provides some protection for the limited partners against liability for the obligations of the partnership, but it also limits their ability to participate in management decisions. There are 2 different partnerships as the following: general partnership and limited partnership. General partnerships. In a general partnership, 2 or more partners share in the ownership, management, and liabilities of the business. Cost and ease of establishment. Partnerships are generally created by written or verbal agreement. No filing at any governmental level is required as long as the partners use their own names. Even if there is no written or verbal agreement, when 2 or more persons share in the profits and control of a firm, a partnership contract is implied. Liability of owners. Each partner is fully responsible for all debts incurred by the partnership or by any partners who act in the firm's interest, unless the creditor has specifically agreed to limit liability to specific assets or partners. Continuity of the business. Unless specified in the partnership agreement, a partnership is dissolved immediately at the death, withdrawal, insanity, or insolvency of any partner. However, the death of a partner does not usually terminate contracts to which the business is already committed. Unless the partnership agreement states otherwise, partners may transfer partnership interests only with the consent of all the partners. However, a partner may, without consent, transfer the right to receive partnership income and assets. Management control. The strength of a partnership should consist of the diverse abilities of the partners. Ease of raising capital. General partnerships can raise capital via the partners. They also have the option of adding partners with capital. Because many partnerships do not want to dilute the interest of current partners, they often rely on borrowing funds. Tax implications. In tax matters, partnerships are treated like proprietorships. Although the partnership is not subject to taxation, it is required to calculate and report partnership income in order to determine the share of net income each partner is entitled to. The individual partners then pay taxes on the proportional shares of net partnership income at the tax rate of each partner. Since the partnership must file a tax return, and because each partner must pay taxes based on the income reported to the government, tax returns can be very valuable sources of information of lenders. Limited partnerships. A limited partnership is a business enterprise formed by one or more general partners and one or more limited partners. Only general partners have decision-making power. Limited partners are passive investors and have no voice in the general business operations, although they do contribute money, property, skill or labor. Cost and ease of establishment. Limited partnerships must be organized under state laws and most comply with statutory requirements. Unlike a general partnership, the creation of a limited partnership requires.
In addition, limited partnerships must notify the public of the existence of partners with limited liability. Liability of owners. Because limited partners don't have a legal right to participate in business decisions, they are liable only to the extent of their investment in the business. General partners in a limited partnership have full liability, as though there were no limited partners. Continuity of the business. The continuity of a limited partnership is exactly the same as that of a general partnership, except that the death of a limited partner doesn't terminate the partnership. Management control. A limited partner cannot participate in the management of the business. Ease of raising capital. Limited partnerships have the advantage of raising capital by attracting investors in the form of limited partners. Tax implications. Limited partnerships carry the same tax implications as general partnerships and proprietorships. Both the limited and general partners in a limited partnership pay taxes on their share of net income. Limited liability partnerships. A limited liability partnership, LLP, is a special type of partnership that restrict to professionals such as lawyers, accountants, and healthcare providers. In most respects, limited liability partnerships are similar to general partnerships, except that generally partners have limited personal liability for negligent acts or malpractice committed by other partners. Corporations. The corporation is the only organization structure that is a legal entity. A corporation is created under state statute and is composed of individuals called shareholders. In essence, the corporation can be thought of as a separate and distinct individual. C corporations. C corporations are the most common type of corporation. Any corporation that is publicly traded is a C corporation. In spite of the initial costs of incorporation, corporate status provides a number of benefits to the owners, including limited liability for obligations of the corporation, and ease of raising additional capital. Cost and ease of establishment. Corporations are by far the most expensive and complicated form of organization to establish. They require detailed record-keeping and filing of reports at the state and federal levels. Verbal agreements are not sufficient in the formation of a corporation. And, in most cases, legal counsel is necessary. Liability of owners. As a legal entity, the corporation limits the financial risk of its shareholders to the amount of capital they have invested unless the owner personally guarantees the corporation's liabilities. The corporation as an entity is separate from its shareholders. It can sue or be sued. Creditors can make claims against the assets of the corporation, but not against the assets of the owners or managers. Continuity of the business. Of the 5 basic business structures, the corporation has the greatest continuity. The legal existence of a corporation is not affected by the death or withdrawal of its managers or shareholders. Management control. The ultimate legal control of a corporation rests with its owners, the shareholders. These shareholders delegate their control to a board of directors. This board of directors, in turn, elects the officers of the corporation, who are responsible for the day-to-day operations of the business. In small, closely held corporations, the stockholders, the board of directors, and the officers are usually the same individuals. Ease of raising capital. The corporation has the most options for raising capital. This is true more for large corporations than for closely held corporations. Large corporations can attract investors in the form of new stockholders. Corporations have many other sources of raising capital besides selling additional shares of stock and borrowing from financial institutions. The very large corporations can borrow directly from the public. Closely held corporations are not usually able to sell debt issues because such companies generally lack the financial strength to attract the number of investors needed to make potential debt issues highly liquid and marketable. They are therefore limited to the same sources of raising funds as are sole proprietorships, their own outside assets, borrowing from a financial institution, or borrowing directly from individuals.